Article 247 of the Revised Penal Code is your death or physical injuries inflicted under exceptional circumstances. And we are still in Title 8, Crimes Against Persons. So let's go now to the elements. So who is your offender or who is the accused in Article 247? Sagot is legally married person or a parent. Again ha, that person must be legally married or a parent. At ano ang nangyari? The legally married person surprises his spouse. As far as the parent is concerned, the parent also surprises his daughter. But ano ang kunatilya sa daughter? That daughter must be under 18 years of age and living with the parents. Saan siya na-surprised? The surprise siya because the spouse or the daughter was in the act of committing sexual intercourse with another person. Next, number 2. The legally married person or the parent kills any or both of them or inflicts upon any or both of them any serious physical injuries. So, pinatay niya or sinaktan niya. Kailan niya pinatay or kailan niya sinaktan? In the act or immediately thereafter. Importante yan ha, in the act or immediately thereafter. Number 3 element, the legally married person or the parent has not promoted or facilitated the prostitution of his wife or daughter. Or that legally married person or that legally married person has not consented to the infidelity of the other spouse. So these are the elements of Article 247. Next, if your situation falls under Article 247, what is the penalty? The penalty is destierro. The person shall suffer the penalty of destierro. But according to the Supreme Court, the penalty of destierro is not really intended as a penalty. Ano ang sabi ng Supreme Court? In fact, that is for your protection offender, that is for your protection accused killer spouse. Bakit? Because by imposing the penalty of destierro, we will be removing you, killer spouse, from the vicinity. Thereby, you will be protected from the acts of reprisal, principally from the relatives sa pinatay mong asawa. Next, Article 247 does not define a felony. It does not define a felony. Bakit? Because sabi nga, the penalty only is destierro. Instead of that severe penalty for parricide, homicide, or serious physical injuries. Since it does not define any crime, therefore, it cannot be alleged in an information. Ano dapat ang mangyari? Dapat magfa-file muna ng case for homicide, murder, or parricide, or serious physical injury, whatever is the applicable, and then you will raise Article 247 as your defense. Very clear, si Supreme Court sabi niya, we therefore conclude that Article 247 of the Revised Penal Code does not define and provide for a specific crime, but grants a privilege or benefit to the accused for the killing of another or the infliction of serious physical injuries under the circumstances mentioned therein. So let's read a bar exam question para hindi nyo na talaga makalimutan. So, B shot and killed A. Sino si A? A is the kalaguyo ng asawa ni B. So, B was sentenced to reclusion perpetua for murder after sa mahabang trial. But it was only on appeal that he was given the proper penalty of destierro under Article 247 of the Revised Penal Code. Question letter B. What is the philosophy of the legal provision imposing the penalty of destierro for the above crime? Ano ang sinabi natin dun sa last slide? The penalty of destierro is intended more for the protection of the offender rather than as a penalty. Destierro will remove the offender from the vicinity and thereby it will protect him from the acts of reprisal, principally from the relatives of the deceased spouse. Another bar exam question, 2005. Tingin agad tayo sa tanong. Under Article 247 of the Revised Penal Code, is destierro a penalty? Actually, parang kaya mo na siyang sagutin, no, yung tanong. But, let's read the facts. Kasi yung facts dito is more or less similar lang din dun sa kaninang slide. At baka meron tayong ma-pick up. So, Pete here is our offender or the accused. He is a security guard, so he arrived home late one night after rendering overtime. But siya ay na-shock because nakita niya yung kanyang asawa, si Flor, and kanyang best friend, si Benji, na engaged in sexual intercourse. So, syempre, si Pete nagalit, he pulled out his service gun and pinatay si Benji. Pete was charged with murder for the death of Benji. So, stop muna tayo. What can you recall? Ano ang sinabi natin? Article 247 does not define and provide for a specific crime. Therefore, it cannot be alleged in an information. Ano ang pwede mo nang dapat gawin? Dapat you should file a case first for murder, homicide, parricide, or serious physical injury, whatever is the case applicable. In our bar problem, the applicable is murder. And then, you will raise Article 247 as your defense. Because Article 247, according to the Supreme Court, is a privilege or benefit to the accused. Tuloy tayo sa kwento. So Pete, when he was charged with the murder for the death of Benji, he contended that he acted in defense of his honor and that therefore he should be acquitted of the crime. But the court found out that Benji died under exceptional circumstances and therefore exonerated Pete of the crime but sentenced him to destierro in accordance with Article 247 of the Revised Penal Code. So is destierro a penalty? What is your answer? Yes, destierro is one of the principal penalties under Article 25. But under Article 247, ano ang sinabi ng Supreme Court? It is not intended as a penalty, but it is only a means to remove the accused from the vicinity for his protection against possible reprisal from the family or relatives of that spouse that he killed or that kalaguyo na kanyang pinatay. Please take note of the second paragraph of Article 247 kasi tinatanong yan sa bar exam. Ano ang nakasulat dyan? If he shall inflict upon them physical injuries of any other kind, then the offender or the accused shall be exempt from punishment. Kung ang na-inflict niya is hindi serious physical injuries but only slight or less serious physical injuries, then he shall be exempt from punishment. How about the liability suffered by third persons? Ano ang sabi ng Supreme Court? The accused also cannot be held liable for injuries sustained by third persons as a result thereof. Bakit? Bakit ganyan ang rule? Because if you read Article 4, under Article 4 of the Revised Penal Code, if you are committing an offense, then you would be liable for the result. You'll be liable for all the consequences of your action or your act. But Article 4 presupposes that the act done amounts to a felony. That the act done amounts to a felony. But if you are acting under Article 247, are you committing a felony? No. If the accused was not committing murder when he discharged his rifle upon the deceased, inflicting death under exceptional circumstances is not murder. This is the reason why that the accused also cannot be held liable for injuries sustained by third persons as a result thereof. So let's go to a bar exam para lalo ninyong maintindihan. The husband discovered his wife in sexual intercourse with her kalaguyo. So the husband immediately fired upon the paramour, inflicting on him less serious physical injuries. But that same bullet that hit the paramour also hit a stranger, killing him instantly. Question: did the husband incur criminal liability in wounding the paramour? Answer is no. The husband did not incur criminal liability. Bakit? Because what did we say according to Article 247, second paragraph? If he shall inflict upon them physical injuries of any other kind, then he shall be exempt from punishment. Since the husband inflicted only less serious physical injuries, then he is exempt from punishment. Question number 2. Will you make the husband liable for the death of the stranger? Answer is no. The husband is also not liable for the death of the stranger. Bakit? Because the stranger here was killed by the same bullet. Ano yung bullet? The bullet which hit the paramour. And when the husband in shooting that paramour suffered only less serious physical injuries, and according to the law, he did not incur criminal liability. Therefore, in accidentally killing that stranger, he is not also liable. In fact, in a case, sabi nga ng isang case, it would be an accident which is exempting. So, balikan natin ngayon ang elements. We are going to define terms. So, what is the meaning of sexual intercourse under Article 247? Ano ang sabi ng Supreme Court? There must be vaginal penetration by the penis. Again ha, there must be actual sexual intercourse, meaning to say there must be vaginal penetration by the penis. Next, sexual intercourse does not include preparatory acts. In the act of committing sexual intercourse, it does not include merely sleeping on the same bed. But the requirement of the law is that that legally married person or parent must surprise his spouse or daughter in the act of committing sexual intercourse with another person. Strict ba ang application niyan? What did the Supreme Court say? Sabi ng Supreme Court, it is not necessary that the spouse actually saw the sexual intercourse. It is not necessary that the spouse actually saw the sexual intercourse. It is enough that he or she surprised them under such circumstances that no other reasonable conclusion can be inferred that a carnal act was being performed or has just been committed. So pag kayo ay confronted ng Article 247, dapat first na tanong nyo sa sarili nyo is, kailan niya nakita, saan nakita ni offender, was it in the act of committing sexual intercourse? So that would be your first question when you attack a problem. 2016 bar exam question, Jojo and Filipa are husband and wife. Jojo is a lawyer, so sabi niya, parang yung kinikita ko is already enough or sufficient to provide the needs of my family. So, kinonvinced niya si Filipa to be a stay-at-home mom and care for their children. But one day, Jojo arrived home earlier than usual and he caught Filipa in the act of having sexual intercourse with their female yaya Alma in their matrimonial bed. So siya ay nagalit, kinuha niya yung kanyang baril and shot Alma, the nanny, immediately killing her. Question: is Article 247 applicable in this case given that the paramour was of the same gender as the erring spouse? Answer is no. Article 247 is not applicable. Bakit hindi applicable? Ano ba ang sinasabi ni Article 247? The offender must catch his or her spouse in the act of committing sexual intercourse with another person. In fact, sabi ng Supreme Court, the accused should surprise his spouse in the very act of sexual intercourse. But ano ulit ang ibig sabihin ng sexual intercourse? It generally presupposes that there is penetration of the man's sexual organ into that of a woman's. In our case, the paramour was of the same gender as the erring spouse. As such, legally, there is no sexual intercourse to speak of. That is the reason why Article 247 is not applicable. So again, take note of the meaning of sexual intercourse. There must be a vaginal penetration by the penis. 2015 bar exam question, nabanggit na natin to when we were discussing parricide, but let's read it again. Procopio here is a call center agent, so he went home earlier than usual. So he proceeded immediately to their bedroom to change his clothes. But to his surprise, he found his wife Bianchi in bed making love to another woman, Magna. So sa kanyang galit, kumuha siya ng knife and he stabbed Bianchi, the wife who died. So parang parehas lang ng facts dun sa binasa natin kanina. So question, what crime did Procopio commit and what circumstance attended the case? Answer is, the crime committed by Procopio is parricide. Bakit parricide? Because according to the Supreme Court, Article 247 is not applicable in this case. It could have been death under exceptional circumstances if Bianchi was in a sexual intercourse with a man, but Bianchi was having homosexual intercourse with another woman. Homosexual intercourse is not within the contemplation of the term sexual intercourse in Article 247. So take note magkaiba yung homosexual intercourse from sexual intercourse. Because what did we say again? What is the meaning of the sexual intercourse? There must be vaginal penetration by the penis. Another bar exam question, Juan came upon his wife and the Kalaguyo, whose name is Isabelo, in a secluded place covered with underbush. So his wife was getting up while Isabelo was standing and zipping up his pants. So Isabelo took to his heels when he saw Juan, who chased him with a balisong knife. So he was not able to catch up with the Kalaguyo, so Juan returned to his wife. At sa kanyang galit, sa kanyang nakita, he stabbed his wife repeatedly with the knife, killing her immediately. Juan's defense at the trial was his having surprised his wife under circumstances indicative of carnal intercourse with Isabelo, and therefore Juan claimed that he should be acquitted. Decide with reasons. Pwede bang mag-apply ang Article 247 kay Juan? Answer is no. Article 247 is not applicable. Bakit? Ano ang sinasabi ulit ni Article 247? Element number 1, you should surprise your spouse in the act of committing sexual intercourse with another person. But ano ang sinabi ng Supreme Court? It is not necessary that the spouse actually saw the sexual intercourse. It is enough that he surprised them under such circumstance that no other reasonable conclusion can be inferred that a carnal act was being performed. Nung nakita ni Juan that his wife was getting up and Isabelo was standing, zipping up his pants, according to the Supreme Court, that is not enough conclusion that a carnal act was being performed or has just been committed. This is the reason why Article 247 is not applicable. Therefore, Juan should be liable for the crime of parricide for killing his wife. Another bar exam question, feeling homesick and terribly missing his wife, itong si Ronald without notice came home from Saudi. So pagdating niya, dumiretso siya agad sa kanilang bedroom. But he saw his wife lying on their bed under a mosquito net, locked in embraced with his kumpare Dante Ayala. So ano ang sinabi natin? If you will be confronted with a question of Article 247, ang unang tanong mo dapat is, saan mo nakita, kailan mo nakita? Dapat nakita mo sa pagtatalik, in the act of committing sexual intercourse. So, but in this case, hindi mo sila nakita. So, what is the question? Letter B. Suppose Ronald shot Dante and his wife while Dante was on top of the wife of Ronald, thus killing both of them. Will you grant him the benefit of Article 247? What is the answer? Yes, of course, you will grant him the benefit of Article 247. Bakit? Ano ulit ang sinabi ng Supreme Court? It is not necessary that you, asawa, makita mo talagang nagtatalik ang iyong misis sa ibang lalaki. It is enough that you surprise them under such circumstances that no other reasonable conclusion can be inferred that a carnal act has just been committed. In fact, ang sabi nga ng UP Law Center, to an ordinary prudent person, pag ikaw ay makikita mo ang lalaki on top of your wife at nasa marital bed nyo pa, such act in the mind of the husband would mean nothing else but pagtatalik. So let's discuss now element number 2. Papasok lang sa element number 2 if you are already satisfied with your element number 1. Meaning to say, nakita talaga ni accused offender in the act of pakikipagtalik, or a conclusion can be inferred that a carnal act has just been committed. So, element number 2, rather, answer the questions when. Kailan pinatay ni offender accused, or kailan siya nag-inflict ng serious physical injuries? Was it during the act or in the act or immediately thereafter? But what is the meaning of immediately thereafter? Ano ang time frame niyan? Ano ang sabi ng Supreme Court? There is no set time, because if you will read your jurisprudence, merong 1 hour after the act of committing or even 4 hours. Therefore, pumasok yan sa meaning ng immediately thereafter. But what is the most important is the act, meaning to say the killing or the infliction of the serious physical injuries must be a direct result of the outrage of the spouse and continuous act from the moment of the surprising. Ano ba ang ibig sabihin ng continuous act? From the discovery to the escape to the pursuit and the killing, all of those must all forms part of continuous act. So take note ha, take note. So for application, let's read this bar exam question. Marco surprised his wife Rosette and the former boyfriend of Rosette, si Raul, both naked and in the act of pagtatalik. It happened at 10 o'clock in the evening. So take note ha, 10 o'clock in the evening. So itong si ex-boyfriend si Raul, yung kalaguyo, he got his baril, and upon seeing the baril, itong si Marco, the husband, ran toward the street, took a pedicab, and proceeded to the house of his brother. His brother is a policeman. Kaya pumunta siya sa bahay ng kanyang brother so that he can borrow a revolver. So with the weapon now, he returned to his residence. but he was not able to find his wife Rosette and Raul, so Marco proceeded to a disco that is jointly owned and operated by Raul. It was already 11 o'clock at that evening when he arrived at the joint. So upon seeing Raul with two male companions, that is A and B, drinking beer at one of the tables, itong si Marco fired two shots at Raul. The first shot hit Raul on his forehead and the second bullet hit A, injuring him on his stomach. So what happened? Raul died instantaneously. But what about A? What happened to A? Because of the timely medical attention given to A, he was able to survive, but he was hospitalized for 45 days. So Marco was prosecuted for murder for the death of Raul and frustrated murder in the case of A. So you are now the lawyer of Marco. So role-playing tayo. What is your defense? Answer: as far as Raul is concerned, your defense would be Article 247. The death of Raul is death under exceptional circumstances. Although the killing happened 1 hour after having surprised the spouse, that would still be within the context of immediately thereafter. Ano ulit ang sinabi natin sa element number 2? Kailan mo papatayin? In the act or immediately thereafter. Meron bang time frame ang immediately thereafter? Sabi ng Supreme Court, it could be either 1 hour or 4 hours. Walang time frame. What is the most important is the act done must be a direct result of the outrage of the spouse, and the discovery, the escape, the pursuit, and the killing must all form parts of one continuous act from the moment of the surprising. So please take note ha. But how about si A, yung kasamahan ni Raul? What would be now your defense? Your defense is Article 4. What is Article 4 again? Ano ang sinabi natin? Under Article 4, one is liable for all the consequences of his act. One committing an offense is liable for all the results of his act. But that rule presupposes that the act done amounts to a felony. When Marco shot or discharged his rifle, he was not committing murder. Inflicting death under exceptional circumstances is not murder. Therefore, the accused also cannot be held liable for injuries sustained by third persons as a result thereof. So please take note ha. Let's read another bar exam question. Yung facts dito is very similar dun sa binasa pa lang natin. Almost identical. So who is the accused here? The accused is Juan Santos. So he is reviewing for the 1983 bar examinations. So meron siyang asawa but his wife was left behind in Davao City. But itong kanyang asawa ay merong kalaguyo, si Pedro. But sometime in July 15, 1984, itong si Juan Santos ay bumalik sa Davao. At around 6 o'clock in the evening at that time, he went to their home, and upon reaching his home, the accused found his wife Laura and Pedro in the act of pagtatalik. And when the wife and Pedro noticed the accused, the wife pushed her paramour and si paramour kinuha yung kanyang baril. The accused, who was then peeping above the built-in cabinet in the room, jumped down and ran away. So what did he do after? He went to the house of his friend. His friend is a soldier at kinuha niya yung M16 rifle and bumalik siya sa kanilang bahay, but it was almost 6:30 p.m. Not finding his wife there, he went to the hangout of Pedro and found Pedro playing mahjong. The accused fired at Pedro 3 times with his rifle, hit him, and also he hit 2 bystanders. Pedro died instantaneously of wounds in the head, trunk, and abdomen. How about the 2 bystanders? They were seriously injured, but they survived. Question number 1. Can Juan Santos be held guilty for the death of homicide for the death of Pedro Orsal? Answer is no. Juan Santos is not liable because of Article 247. Also, take note, yung oras, nakita niya ng 6 o'clock pero napatay niya ng around 6:30 or 7. But what did we say again? That is one continuous act. Pasok pa rin yan sa definition ng immediately thereafter as stated in element number 2. Let's go now to the second question. What offense did Juan Santos commit with regard to the 2 bystanders? Answer is Juan Santos committed the crime of serious physical injuries inflicted under exceptional circumstances. Take note ha, ang tinatanong lang sa letter B is what offense did he commit? So, there is no need for you to answer na hindi siya liable for the offense committed against the 2 bystanders. Just answer the question. Huwag magdagdag ng sagot or ng tanong. So, let's summarize our discussion through this bar exam question. So, A and B are husband and wife. Itong si A is a security guard at Landmark. Ang kanyang shift is 11 p.m. until 7 o'clock in the morning. But one night, parang feeling niya meron siyang sakit. So, he decided to go home. And upon reaching the front yard of his home, napansin niya that the light in the master bedroom was on and that the bedroom window was open. So, approaching the front door, nakarinig siya ng sighs and giggles inside the bedroom. So, he opened the door very carefully and he was surprised to see his wife na nakikipagtalik sa kanilang kapitbahay na si C. So, A rushed inside and grinab niya si kapitbahay. But si kapitbahay was able to manage himself free and jumped out of the window. But sinundan pa rin siya ni A and managed to catch C again, and after a struggle, pinatay niya, he strangled to death C. A then rushed back to his bedroom where his wife was cowering under the bed covers. Dahil galit na galit, A hit B with fist blows and rendered her unconscious. So the police arrived and arrested A, who was detained, inquested, and charged for the death of C and serious physical injuries of B. So question, is A liable for the death of C? Answer is Article 247. He could have been liable for the death of C, but dahil pumasok siya sa Article 247, the facts mentioned in the problem is pasok. Yung element number 1 was present. Element number 2 was also present. Then, the penalty that could be imposed only to A is destierro. Only destierro. How about letter B? Is A liable also for the injuries of his wife? Answer again is he could have been liable, but because the serious physical injuries were inflicted under the same exceptional circumstances mentioned in Article 247, then the penalty that can only be imposed to A is destierro. And what did the Supreme Court say? Actually, destierro is not a penalty. Ang purpose niyan is only to remove you from the vicinity para hindi ka ngayon balikan ng kamag-anak ng pinatay mong asawa.